Rule 112, Preliminary Investigation. Section 1. Preliminary investigation defined when required. Preliminary investigation is an inquiry or proceeding to determine whether there is a sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and shall be held for trial, except as provided in Section 7 of this rule. A preliminary investigation is required to be conducted before the filing of the complaint or information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day without the regards of the fine. Section 2. Officers authorized to conduct a preliminary investigation. The following may conduct a preliminary investigation. A. Provincial or city prosecutor and their assistants. B. Judges of the municipal trial courts and municipal circuit trial courts. C. National and regional states prosecutors. And D. Other officers as may be authorized by law. The authority to conduct preliminary investigation shall include all crimes cognizable by the proper court and the respective territorial jurisdiction. Section 3. Procedures. The preliminary investigation shall be conducted in the following manners. A. The complaint shall state the address of the respondent and shall be accompanied by the affidavits of the complainant and his witnesses, as well as the other supporting documents to establish probable cause. They shall be in such numbers or copies as there are respondents, plus 2 copies for the official files. The affidavits shall be subscribed and sworn to before any prosecutor or government official authorized by administer oath, or in their absence or unavailability, before an authority public of whom much certify that he personally examined the affiants and that he is satisfied that they voluntarily executed and understood their affidavits. B. Within 10 days after the filing of the complaint, the investigating officer shall either dismiss it if he finds no grounds to continue with the investigation, or issue subpoena to the respondent attaching to it copy of the complaint and its supporting affidavits and documents. The respondents shall have the rights to examine the evidence submitted by the complainant, which him may not have been furnished, and to copy them at his expense. If the evidence is voluminous, the complainant may be required to specify those which he intends to present against the respondent, and this shall be available for examination or copying by the respondent at his expense. Objects as evidence. Need to be furnished a party but shall be made available for examination, copying, or photographing at the expense at the requesting party. C. Within 10 days from receipt of the subpoena with the complaint and supporting affidavits and documents, the respondent shall submit his counter-affidavits and that of his witness and other supporting documents relied upon his defense. The counter affidavits shall be subscribed and sworn to and certified as provided in photograph A. This section, with copies thereof, furnished by him to the compliant. The respondent shall not be allowed to file a motion to dismiss in leo of a counter affidavit. D. If the respondent cannot be subpoenaed, or if subpoenaed does not submit counter affidavit within the 10 days period, the investigating office shall resolve the complaint based on the evidence represented by the complainant. E. The investigating officer may set a hearing if there are facts and issues to be clarified from a party or a witness. The parties can be present at the hearing, but without the right to examine or cross-examine. They may, however, submit to the investigating officer questions which may be asked to the party or witness concerned. The hearing shall be held within 10 days from submission of the counter affidavit and other documents or other expiration of the period for their submission. It may be terminated within 5 days. F. Within 10 days after the investigation, the investigating officer shall determine whether or not there is a sufficient ground or hold respondent for trial.